Around 30 years ago, a landmark law reshaped how the United States addresses gender-based violence. But what is VAWA, and why does it remain critical today? On September 13, 1994, the Violence Against Women Act, or VAWA, became the first federal law to classify domestic violence and sexual assault as crimes. The National Organization for Women and its allies led the fight, securing $1.6 billion for violence prevention and survivor support. For decades, NOW laid the groundwork for VAWA through tireless advocacy. In 1973, they created the NOW Task Force on Rape, establishing crisis hotlines. In 1975, they organized the first Take Back the Night marches against sexual violence. From 1990 to 1994, NOW lobbied Congress to pass VAWA, ensuring federal action against domestic violence. And from the 2000s up until the present, NOW has expanded protections for Native women, LGBTQ+ survivors, and online harassment victims. Before VAWA, domestic abusers could cross state lines to avoid prosecution, and law enforcement often dismissed cases. Thanks to VAWA, protection orders are recognized nationwide. Federal charges can be filed against abusers who flee across states. And law enforcement and judges receive specialized training to support survivors. Despite its impact, VAWA has faced legal and political challenges. In 2000, the Supreme Court struck down a key provision that allowed survivors to sue their attackers in federal court. Every reauthorization has expanded VAWA's protections, but there's more work to be done, like closing the boyfriend loophole to prevent convicted abusers from owning firearms, addressing cyber harassment and AI-generated abuse, and strengthening resources for marginalized communities. VAWA is more than a law. It represents a cultural shift in how we combat gender-based violence. If you or someone you know needs legal guidance, VAWA attorneys can help. Let's continue advocating for stronger survivor protections, because no one should suffer in silence.